You guys can see my slides? And somebody reply.
Yes, sir.
Okay, thank you. So far we discussed about patents, right? So now today we're going to discuss about industrial design. So what is the industrial design? Industrial design relates to the appearance of an article resulting from lines, colors, or ornamentation of the article. So basically, industrial design mainly focus on appearance of the article. It will basically try to protect the ornamentation of the article. So how the if it is a 3D or 2D, how it looks like. So the appealing aspects of the item we can protect by using design registration. So in US it is called design patent, but in India it is called industrial design registration only. It is not called patent, design patent. So in India it is called as industrial design registration. So basically you are trying to protect the appearance of an article. So if you take a 3D picture of an article, you can see there is a cycle. So how the cycle looks like, the appearance of the cycle you can protect. So industrial design does not protect the features. For example, unlike patent protects the innovation or uh, what kind of features that patent will protect. But coming to the industrial design, only appearance of an article only. For example, if an article is a 2D feature, 2D feature, then it will protect like pattern, line, and color. So you can see 2D features are here like this, and 3D features are like this. Only appearance of an article only it will be protected through industrial design. Why protect industrial designs? So why do we want to protect industrial design? What is that we're gonna get it? That we're gonna discuss here. The appearance of a product can be a key factor in the consumer's purchase design. The success or failure of a product may rest at least partially on its look. For example, if you are going to buy a mobile, so aesthetic appeal also, apart from the features, there might be so many features in the mobile. Apart from if you can see that there are two mobiles which are having same kind of features, but if the appearance is different, one mobile is looking appearance, aesthetic appeal, it is really good, then obviously the consumer will prefer that one, like which one is looking really good. So in that way, the appearance of a product also makes decision of the consumer. So that is the reason we are protecting the design. So therefore, to successfully commercialize a product, an enterprise, that means any company, generally invest time and money to innovate, develop, and create articles with a newer original designs. So because that also makes consumer to think that if the aesthetic appeal is really good, definitely consumer will go with that. So that also one of the key choice apart from the features of that article. So that's the reason we are protecting designs. We are encouraging creativity in the design also. So if you start protecting and if you start encouraging, so ultimately we get a best product in terms of aesthetic appeal. When companies are competing at equal price and functionality design is the only differential that matters. So this guy says that that's what we discussed it, like if functionality and everything is same, so the design will make a bigger role there in choosing the item for a consumer. So what are the benefits of the registration? So you get an exclusive right to apply design to the article in the class in which design is registered. So now we understand that we can register the design, we can protect the design, industrial design. That means you can protect the aesthetic appeal. So after protecting that, and if you register that design, so you will get an exclusive right. So what are the exclusive rights? You will get it, that we will discuss in the next slides. And while registering your design, there are several classes are there. So based on your ornament or based on your article, so it has been divided into the different classes, and the classes are again divided into subclasses. Though this kind of classification is called follows Locarno classification. For example, if you want to protect a design of a sofa, so sofa belongs to a specific class, and under class there are some subclasses also there. Maybe if the sofa belongs to some specific subclass. For example, if any bike, if you want to protect that design, it belong to a different class. So these classes are standardized through Locarno classification. This classification in entire world, almost most of the countries follows Locarno classification, including India. We follow Locarno classification, like standardization. So everybody uses same set of categories, and protection, and can sue for piracy of a design. What is piracy of a design? Piracy of a design means, piracy means without the consent of the industrial design registration owner. So you are copying it and you are selling that. So if you are uh, indulging in these activities, that is called the piracy. So if you register, you will get protect from the piracy. And also another advantage is licensing of design as legal property for consideration or royalty. So if you protect your design, you will get some royalty, you will get a consideration. So because anybody else in the world, if they want to use your design, because it is registered on your name, so if they want to use that design, they have to pay a royalty to you. Then only they are eligible to use that. Otherwise, you can sue them. And also, it helps obtain return on investments, because you registered, and whoever want to use your design, so they have to pay the royalty. So provides exclusive rights. It it provides exclusive right to exclude others from copying your design, and facilitates marketing and commercialization. So because it is registered, you will have a better market. Wherever the market is there, there you can go and sell your design, and you can commercialize. Commercialize means you can license it. Through licensing, you can get the royalty. So you can generate the money. So that is what they are saying. And also is a revenue generator. So these are the benefits of registration. So you can see how you can set the registration. You can search the, I mean, how you can uh, see your registered design. So this is the link, search.ipindia.gov.in design search. So I will show how to search your design. Imagine if the design is registered. And also you can see there are so many luxury items, and mostly the consumer uh, here, uh, he will decide based on the aesthetic appeal, based on the how it looks, so how good the design is. If you protect this, nobody else can copy your design, unless he get a consent from you, he cannot copy from you. So if you see so many luxury items, including dresses, attires, so you can protect design on that. If you don't protect, somebody will copy that, and it is a huge loss for you because you spend a lot of time to create this design. So you can see here, here there is a medical device. It has been registered. So here one thing we have to understand that it is not protecting the functionality. Functionality will be protected, as you know, that is through patents. We are protecting only aesthetic appeal only, like which is solely judged by eye, your eye. So your eye will say that whether it's a good or whether it is really beautiful or not. So those aspects only it will protect. So for example, if you see there is a design number here, after you register, you will get a design number and class. As I said, as I discussed earlier, class is a Locarno classification, and 12 is the class number and 2 is the subclass number. So this design, you can see on the right side down, this kind of trolley. This design belongs to this class. If and this is the address, and this is the date of registration, and the title is trolley for medical aid. So based on the design number, you can search also. For example, in the previous slide, I have shown one website. If you can open the website, and if you search this design number, it will directly show this one. So we will see at the end of the class, we will see like how to search under. This is for houseware and furniture. You can see the design of the chair. It's not the functionality. Design of the chair has been protected. So design number and class, it belongs to class 6 and subclass is 1. And title is chair, and date of registration also you can see, and corresponding address of the company. He is the applicant, and you can see another chair. The class is because both are chairs, so the class and subclass are also same, and you can see the date of registration. Electrical appliances, you can see the design number and class is 7 and subclass is 05. So these are the date of registration, and title is iron. So iron basically under subclass 7 and C. This is standardized. This is called Locarno classification. This is the link for the Locarno classification. This classification is maintained by World Intellectual Property Organization, which is there in Geneva. So these are the several designs. You can protect design features through industrial design registration. So it is applicable even for this. For example, see for automobiles also, this is the design number and class 12 and 11 is the subclass, date of registration. So vehicle appearance and also architectures. This design also you can protect through industrial design. And as I said, 2D, two-dimensional textile designs also you can protect. Even for dresses, on top of the dresses, whatever the design, you can protect. This is the class number, and this is the creator address and date of registration and title. This priority is nothing but, so there is a convention for event design, the way for patent. So Paris Convention or PCT, Patent Cooperation Treaty, in the same way. For design also, there is a convention that we will discuss in the next slide. So, and also these convention countries, within 6 months, you can file in a convention country. So in that way, the priority date, you can secure the priority date. For example, you file in India, and within 6 months, you also can file a convention country. So your priority will be protected. That means it is valid there also. It will be treated as if you filed the day when you filed in India. So the priority is, but within 6 months, you can file anywhere else, any other country, conventional country in the world. So graphical user interface, this also navigation system. This also we can protect by using design registration. So now when it comes to law, because I have given all the slides to make you understand that, you know, what are the designs, why we need to protect the design, and what is that we're going to protect, and what is that piracy, and how we get rid of from the piracy. So I just gave a brief introduction. Now when it comes to act, this is the actually the act, the jurisprudence that has been developed during the years. Here in 1872, it is called the Patents and Design Protection Act, and later it became the Inventions and Design Act. See, here earlier patents and design together there is a single act. So in 1911, the Indian Patents and Design Act. So in 2000, they separated Patents Act and Design Act again, and it is called the Design Act 2000. So you can see on the right side, this is the Design Act 2000, and corresponding rules are, this is the act, and corresponding rules are the Design Rules 2001, and that got amended in 2008 and 2014. So now we are following 2014 rules, and the act is the Design Act 2000. Why we separate rules and act? Because act should be in the parliament, it should be approved by upper house and lower house, and then president consent, then only the bill become act. If you want to modify anything, it is very difficult every time you get a approval from Lok Sabha and Rajya Sabha and then president. So some of the things they keep in rules. So if you want to change the rules, government can change it. For rules, you no need to change it. You no need to get the consent from the parliament. So that's the reason they segregate. So whatever the timelines and rules and guidelines and everything they keep in the design rules. So that if government want to change, they can change. They can bring the amendment without getting the approval or consent from the parliament. But act, definitely you have to get it approved by the parliament, because parliament is the one having supreme power that we are selected. We our representative of the people represent the parliament. So our voice will be represented in the parliament. So any bill will become act there. So when it comes to definition of the industrial design, so only the features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in two-dimensional or three-dimensional or in both the forms, by any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which in the finished article appeal to and are judged solely by eye. So I will take each and every part and I will explain. So for now, only the features of shape, configuration, pattern, ornament, or composition of lines or colors. Only these things only, if it is in two-dimensional or three-dimensional. If it is a mechanical or chemical or combined process. So, and it should be only judged by the eye only. So this is nothing but, you know, aesthetic appeal. So these features only will be protected under Industrial Design Act. That is what mentioned in Section 2D. But it does not include any mode or principle of construction. That means any functionality features that it is not going to protect. Any trademark. So any trademark also it is not protected. Any artistic work as defined under Copyright Act 1957. So as per the Copyright Act, that we will discuss copyright and all in the further classes, Copyright Act. So whatever it has been defined in Copyright Act, what is artistic work, that doesn't cover under industrial design. So I will discuss in detail. This is a very important one, definition. Now I will discuss in detail what exactly it says in the next slide. If you take understanding the scope of the design and exclusion. So if you want to protect your industrial design, it should be new and original. So what is new and what is original? Now we will discuss here. The term new generally refers to something different from what has been done before, while original denotes something originating from the other. So these two concepts are important in the context of design. So the first criteria to design, to protect your design, so it should be new and original. What is new? New means it should not be something different from what has been done before. Like it should not be available in the public domain before you file. And also original means it should come from it should not be copied from someone. It should originally come from you. That means author. So these two concepts are one of the criteria for industrial design registration. And another one is copyright and design, exclusive right and applicable section 2C of the Act. Okay. Section 2C of the Act, copyright grants the exclusive right.
Sorry, sir.
Means, hello. Say. Anybody speaking? Okay. Copyright grants the exclusive right to apply a design to any article in any class in which the design is registered. So this means that owner of a copyright protected design has the sole authority to apply that design to articles in the registered class. So here copyright means not related to Copyright Act 1957. What here they are trying to say is after a design registration, you will get a copyright on your design. So the right to copy. So once you register your design, so you will have the right. So if anybody want to use your design on their article, to apply on their article, so I need to get a consent from you. That is called copyright. So I wanted to copy your design. So for that, please give me the consent. So whenever you register your design, so you will get a copyright on that design. So anybody else want to use your design, you wanted to take a consent because you have the right to copy. You are the owner and you also registered. So that's the reason somebody else has to take the permission from you. So and aesthetics and exclusions. So if I want to explain what is this aesthetics and exclusions, as defined in section 2D of the Act, mainly focus exclusively on the aesthetic aspects of an article. That is what I discussed earlier. So it is focusing on aesthetic aspects, not on the functionality aspects. It includes features such as shape, configuration, pattern, ornamentation, or composition of lines or colors, as defined in section 2D. The evaluation of a design is based solely on its visual appeal to the eye. This I already discussed. And the next one is exclusion of functional aspects and mechanical devices. So some are not protected under industrial design. What is that it is not protected? Those are mentioned here. It is important to note that the definition of design does not include any mode or principle of construction or anything that is essentially a mechanical device. The focus of design protection is purely on the visual appeal and appearance of an article. So it protects only visual aspects only. It does not protect any functionality, or it does not protect any mode or principle of construction. So through this way, some shapes can come out, okay, through some functionality way. So that cannot be protected. For example, if you take a tire of a round only, so that round functionality you cannot protect it, saying that that is a design, because through functionality that became a drawing. And if you take example, if you consider a chair, would encompass its shape, pattern, or ornamentation. However, the way the chair is assembled, the type of joints or mechanism used for stability or adjustability, or any functional elements like wheels or levers would not be part of the design. If you take a chair, only shape, pattern, or ornamentation only protectable. Like, the functional aspects of the chair, you cannot protect by using the design. And also another exclusion that you cannot protect through design is trademarks, which is defined under section 2 GB of Trademarks Act 1990. So basically, I am discussing about and what is the criteria for design registration, and what is that it is not protected through design. So those exclusions I am discussing, and what is new and original, which is needed to register your design, and other exclusion, what is the right you're gonna get it, what are the aesthetics, what do you mean by aesthetics, and what are the exclusions, what is that it is not protectable under the Design Act, that I am discussing, and I will discuss. This is all comes under single definition, that is called industrial design. So if you take a next slide, design protection does not encompass trademarks. As I discussed earlier, it cannot protect a trademark. Trademark, which is different. Trademark also you will come to know in the next classes, Trademark Act. So far you guys come to know the Patent Act only, right? And this is the second act. This is the Design Act. So whatever is designed, trademarks are not protected under design. That is what this trademarks are distinct symbols or marks used for brand application. Why we use the trademarks? Trademarks, for example, by seeing the brand, for example, there is a paste or there is a mobile like Apple. By seeing the brand, you will proceed with, you will take the decision. So trademark actually protects the brand, goodwill, and reputation. So the trademark can be any mark. Those marks cannot be protected under design registration. Design is only for aesthetic appeal only. It cannot represent any functionality, or it cannot represent any brand or goodwill or reputation. That's the reason it has been excluded. Even it cannot represent any uh, what is that, artistic under Copyright Act. So that means any expression also, it cannot be protected under design. So whatever is in copyright, artistic design, artistic under copyright, and trademark under Trademark Act, these cannot be protected under design. So for example, the logo of a company displayed on a product would be considered a trademark, not a design, because trademark represent the brand, goodwill, and reputation. The logo's primary function is to identify the company rather than solely contribute to the visual appeal. Trademark is for to identify the company. For example, if you see there is a mobile that is there is an Apple logo. Based on that, you can see, oh, this mobile has come from the Apple, and it represents reputation, goodwill, and brand. It doesn't represent any visual aspects. So visual aspects only can be protected by industrial design. And another exclusion is property marks. What does the property mark? Property marks is nothing but uh, to identify. The property mark is a unique identifier used to indicate ownership of a specific property. So this is actually defined under section 470 of the IPC, address the legal aspects of the property marks. So even the property marks also cannot be protected under design. And another exclusion is artistic work. As I said earlier, this artistic work, which is defined under Copyright Act. So this one also not protected. What is artistic work? It's something like painting and sculptures and drawings. So copyright protects only expression only. It does not protect the functionality. It does not protect the aesthetic appeal. It does not protect brand or goodwill reputation. So it only protects the expression. So this one also And these kind of expressions like artistic works also cannot be protected under design. So basically I'm discussing the exclusions. What is that it cannot be protected under design? Why it is not protected also I'm explaining. Copyright only protects the expression only. For example, if you take a painting, how you are drawing how you are painting it. If you take sculpture and drawings, so it protects the expression only. It doesn't protect the functionality or any aesthetic appeal. When it comes to copyright, it protects the expression. So, example, a unique sculpture or a hand-painted artwork would fall under the realm of artistic works and be protected by a copyright law rather than being classified as a design. So this is the example, and I said focus on aesthetic aspect, which is defined in section 2D. So totally, if you summarize, what are the exclusions? Exclusions are functionality. That means if any functionality or trademark or property mark or artistic works, this cannot be protected under design. Only aesthetic appeal will be protected under design. So far I explained what is design and what is that it can be protected. What are the exclusions? What is that it is not protected? So once you have come up with design which is novel and original and which is a distinctive one, and then you can directly file a design application. So this is the process in the design Controller General of Patents, Designs and Trademark Office. You can file design. So design headquarters is in Kolkata. So this is the process. So you can file through online. So you don't need to go anywhere. So first filing of application. As soon as you file the application, you will get the numbering and date of application. And after that, your application will be examined by the design office, patent control general patent design and trademark office, that is actually called. And then if any objections are there, where you will get the objection, because if it is not novel or if it is not original or if it is not distinctive or if it is a copied one from somebody, if it is already exist in the public domain, so then those designs are not registerable. So if that kind of design, if you want to register, so definitely CGPTD, Control General Patent Design and Trademark Office, definitely will give the objections and they will communicate the objections to you. And if you non-compliance of objection, if you are not compliance with those objections, your application will be abandoned. There is a time limit. Within the time limit, you have to comply with the objections that was given by the patent office or design office here. If you don't comply, your application will be abandoned forever. So if you can comply, if you want to comply, so you can ask for the hearing. That means you can directly go to the design office, Kolkata, and you can ask for the hearing because you wanted to get the registration as soon as possible, and you wanted to convey that whatever the objection they have mentioned, there is a valid grounds, and waiving or removal of objections. If you can satisfy them that these objections are not really objections, and if it is acceptable by them, by Control General Patent Design and Trademarks, and notification in the official general, and you will get the issue of the certificate. That means design registration is done for you. In case it is not accepted, in case of allowance of appeal, you can appeal registrar decision to the High Court, saying that whatever registrar is objecting, that is not justifiable, and you can appeal to the High Court, and you can get it done, the registration. So this is the basic flow diagram in the patent design office. Patent and Design Office, Control General Patent Design and Trademark Office. So when designed to apply to the inner portion, these are exclusions. When designed to apply to the inner portion of the article, not visible or noticeable in finished article. You cannot ask for something which is inside of the article or which is not visible. For example, the pot, inside of pot, if any design is there, you cannot ask for that, give me, because give me the design registration for that, because it is inside, it is cannot here. You cannot see, one cannot see. Principle or mode of construction of the article. That means functionality, it cannot be protected. These are the exclusion I'm saying. Building and structures, how they build, how they structure. These functionality aspects cannot be protected. Sole functional features, I told, right? For example, if you take a tire is always round. So that round feature you cannot ask for the design, because it has to be round only based on the because the functionality is the round feature you cannot the round design you cannot go for. But if you can come up with some spikes or something, then definitely it is registrable under Design Act. And part of an article not sold separately. For example, pen and pen cap is there, which is not sold separately, and pen cap some design is there, you cannot solely ask for that for the registration. Variation commonly used in trade. What does it mean? Variation commonly used in trade means something like commonplace designs or common variations typically refer to design elements or features that are widely utilized and recognized within a specific industrial field. Common things, common, for example, geometry, shapes and all, that whatever is the common things in a specific industry that they are using, that you cannot ask for the design because they are very common. And also stamps, labels, tokens, medals, trademarks, cards, etc. All these things you cannot ask for the design registration because they are very common. Mere change in size, by just changing the size, you cannot say that it's a unique design and give me the registration. And also designs contrary to public order, morality, or scandalous. Computer chip or integrated circuit design, because these covers under different act. And design contrary to public order or morality, which is against our morality or public order in India, that cannot be given a design registration for that. And as per section 4, a design which is not new or original. So it should be new or original. Design should be. Then only you will get the design registration. And also has been disclosed to the public anywhere in India or in any other country by publication in tangible form. Tangible form means it's not intangible. It's a tangible, some paper, it is fixed on some paper or something. From or in the computer, from or by use or in any other way prior to the filing date or where applicable, the priority date of application for registration. So if it is already there in the public domain, then sorry, the design cannot be given to you. Registration cannot be given to you as it is already available in the public domain. And if it is not new or original also, the design registration cannot be given for that. And is not significantly distinguishable from known designs or combination of known design. You take some already existing design, and if you can come up with a new design which is not that much distinguishable, then that is also because it is almost similar to the previous design. So it is not distinguishing the existing design. So in that case also, yes, design cannot be given, and comprises or contains scandalous or obscene matters. Some obscene matter kind of designs, definitely that cannot be given. If you satisfy all these things, yes, design can be given to you. So if design has to be registered, it should be new or original, and it should not be in the public domain, and it should be distinguishable, and it should not be comprised or contain scandalous or obscene matter. Then only your design registration will be given. So what are the rights after the registration? The right is you will get the right for 10 years, and that can be extendable for 5 years. What is the right? The right to copy. If anybody want to use your right, they have to take the consent from you, because that is on your name, that is registered on your name. So copyright in design means the exclusive right to apply a design to any article in the class in which the design is registered. The exclusive right that will be registered on you. If anybody want to use your design on my article or something, so definitely I need to take a permission, because you have the copyright on that design. So normally it is 10 years, it can be extendable to 5 years also. For example, if you have come up with some new design, it might be on some saree or it might be on some dress, definitely it can be protectable. And once you registered, the production will be there for 10 years. And what is the right you're gonna get is, that is the copyright. So if somebody want to use your design, so they have to take the permission from you. And if the 10 years are over, before 10 years are getting expired, you can go for the registration. I mean, it can be extendable for 5 years. So maximum 15 years. After that, you cannot renew. So cancellation of registration. So any person interested may file petition for cancellation of registration of design to the controller at any time after the registration with the prescribed fee and form on the following grounds. So based on the following grounds, you can you can go for the cancellation of registration. So if it is previously registered in India, if it is already registered on somebody's name, if you try to register on you, no, that is the ground for the cancellation. And published in India or other country prior to the date of registration. It is already existed and it is already published, or it is already available in the public domain. So then that is the ground for cancellation. If it is already registered on your name. So these are the ground for cancellation. Not a new or original design as per the section 2D. So these are the minimum criteria that design can be registered. So if it is not new or original, not a registrable design under the Act, Design Act 2000, or not a design under section 2D of this Act. So these are the grounds for the cancellation of registration. And during the existence of copyright in any design, it shall not be lawful for any person without the license or written consent of the registered proprietor. So, piracy of registered. So, to apply or cause to be applied the design or any fraudulent or obvious imitation thereof to any article in any class in which the design is registered for the purpose of sale, to import such article for the purpose of sale, to publish or expose or cause to publish the exposure for the sale that article. So, what he is trying to explain, what is piracy? It shall not be lawful for any person without the license, without the consent of the uh, uh, owner of the design registration owner. So it is not allowed. If it is allowed, uh, he can sue you, and the punishment for that is, because there is no penal action, there is no uh, something like, for patent and design, there is no criminal action on you, so sending you to the jail or something like that. But coming to the copyright and trademark, yes, criminal punishment is there. But coming to the design, no, it's not there. So this is very important and remember. So in case of contravention as above by any person, he will be liable to pay a sum not exceeding 25,000 to the registered proprietor, subject to the maximum price 50,000 in respect of any one design. This design might be registered in other classes as well. So maximum it will be 50,000 from 25,000 onwards. So there is no penal, there is no criminal action if somebody violates or for piracy of a design. So this is IPR website. So you can see patent, design, trademark, GI, and this is the Pune institution. So if you see the design, you can see checklist for design application and corresponding forms. And once your design application is filed, and after a few days it will be published. You can see the publication. Even after registered, you can see the publication. And you can see the frequently asked questions if you have any doubts. And the corresponding manual is there. Apart from the act, how to understand the act, if you can see manual, you can understand the act. And acts are there, corresponding rules are there. Act is 2000 and rules are in 2014. These are the latest rules. So finally, to remember, as a general rule, in order to be protected, the design must be new or original. I explained what is new and what is original. What constitutes novelty or originality may differ from country to country. So novelty should be, that means it should be new. It should not be available before you file. And original means it should be from the creator. So it should not be copied, or it should not be like that. If it is from originally created by a creator, so that is called originality. Novelty means it should be new one. It should not exist before you file. So as a general rule, and in accordance with the Paris Convention, industrial design production is territorial. So whatever the right that is given, I'm saying exclusive right, copyright on the design. So that is a territorial right. What is territorial? The right is given by the Indian government. It is valid in India only, Indian territory. This means that industrial design rights are limited to the country where production is sought and granted. So that's the reason IP rights are territorial. It's not because the right is given by the Indian government only. So it is valid in India only. It is not valid anywhere. If production is desired in several countries, maybe in other countries as well, separate national application must be made according to the applicable national law and procedures. Because every country might be having their separate design act, which is approved by their parliament. So if you want to protect same design in their country, so yes, it is possible in a specific period. So that is 6 months as per the Hague Agreement. Whoever is the convention of the Hague Agreement, within 6 months, if you file in some other country, and within 6 months you can file in India or vice versa. So in that case, you can protect your priority. So Hague Agreement is the international convention, something like for PCT and Paris Convention. In the same way, for designs, it is a Hague Agreement. For patent, it is a PCT, Patent Cooperation Treaty, or Paris Convention. So to avoid having to submit application in each and every country where production is sought, the Hague Agreement concerning the International Registration of Industrial Design, which is WIPO, Hague Agreement is maintained by World Intellectual Property Organization, helps to facilitate this process. It enables creators to seek protection for their designs in large number of territories. For example, if you want to protect the same design in some other country, within 6 months you have to file in other country as well. Maximum you can file 3 or 4 within 6 months. So it is very difficult if you want to file more than 3 or 4 countries within 6 months. For that, they have come up with, they means WIPO, World Intellectual Property Organization, have come up with one agreement, International Hague Agreement on designs. So through that, it will facilitate you to file your design. If you file your design, your priority date will be protected in all the convention countries of Hague Agreement. So through single file application, so you are launching your application in all the countries. They will separately examine and give their result. So rather than filing in each and every country individually going, so you can directly file in all the countries which are member of the Hague Agreement. So by filing a single application, so that will be, Hague Agreement is facilitated, administrated by WIPO, World Intellectual Property Organization. So in the case of patent, it is through PCT. In the case of design, it is a Hague Agreement. So in the case of trademark, it is a Madrid protocol. So something like that. So trademark, Hague Agreement. I repeat, design is the territorial right only. So if you want to get protected your design in other countries, you have to file in other countries as well. Within 6 months, you have to file from data first filing in a convention country, or you can directly file through Hague Agreement from WIPO, and whoever the members of Hague Agreement, whichever countries are members of Hague Agreement, if you can file through Hague Agreement, you can protect your priority date in all those countries. That means, which means, as if you are filing in all those countries, though you file a single place, which is WIPO Hague Agreement. So thank you. So still we have 5 minutes. If anybody is having questions, you can ask. Related. So stop.